the permit fight returns. The Supreme Court has just taken up another major Second Amendment case, and this one has the potential to reshape how every state handles concealed carry permits. It came only 2 years after Bruen, when the court struck down New York's proper cause permit system in a 6-3 decision. Instead of adjusting to that ruling, several states moved in the opposite direction, creating new restrictions designed to reduce public carry through technical policy shifts rather than outright prohibitions. Now, the question before the court is simple but unprecedented. Can a state require citizens to seek permission from private property owners before exercising a constitutional right? Millions of gun owners are watching the outcome of Wolford versus Lopez, because if the court rules broadly, it could dismantle permit-based systems nationwide. What makes this case even more significant is that it now has Department of Justice support, state-level backing, and a set of constitutional questions that go far beyond Hawaii. Wolford didn't begin as a national fight. It started as a challenge to Hawaii's concealed carry law, passed in direct response to Bruen. Under Hawaii's new rule, a permit holder is presumed prohibited from carrying on publicly accessible private property unless the owner explicitly grants permission. That flips the traditional assumption on its head. Historically, carry was legal unless a property owner objected. A district court blocked the law under Bruen's text, history, and tradition test. But the Ninth Circuit reversed, reinstating the ban and claiming it aligned with modern policy needs. That split the circuits because the Second Circuit reached the opposite conclusion in a New York case involving similar restrictions. Circuit splits almost always attract Supreme Court review because the Constitution cannot mean one thing in one state and the opposite in another. Now, oral arguments are set for January, unusually fast by Supreme Court standards, and the emergency acceptance tells us the justices see a serious constitutional problem that needs immediate resolution, not years of delay. The biggest surprise so far is not the plaintiffs' arguments, but who joined them. DOJ emphasized that trespass laws already give property owners the power to exclude firearms, making the default ban unnecessary and constitutionally suspect. This matters for two reasons. First, the federal government rarely sides with permit holders in major Second Amendment cases. Second, the DOJ is now seeking to join oral arguments, signaling that the administration wants to influence how the court shapes Bruen's reach. Historically, when the DOJ weighs in, especially on constitutional tests, the court listens. We saw the same pattern in Kitano 2016 and Heller II 2011, both of which reshaped Second Amendment litigation nationwide. The DOJ's position here weakens Hawaii's argument and increases the likelihood of a ruling that reinforces Bruen rather than narrows it. Right after the DOJ filed, 25 states submitted their own amicus briefs urging the court to strike down Hawaii's rule. Many of these states already operate under shall-issue systems or permitless carry frameworks, and they view Hawaii's approach as a backdoor attempt to create modern gun-free zones without using explicit bans. On the other side, 18 states and D.C. filed briefs supporting Hawaii, arguing that property owners have absolute rights to exclude firearms and that the state is merely codifying that right. This sets up a rare constitutional collision. Second Amendment carry rights versus private property regulation. The court has dealt with property power conflicts before. Cedar Point Nursery versus Hasid 2021 is a recent example, where the justices ruled that government-mandated access onto private property triggered takings concerns. Wolford raises a parallel question. Can the government weaponize property rights to restrict a separate constitutional right? That question has not been answered directly before, and how the court resolves it could affect future litigation far beyond gun cases. At the center of Wolford is the question the court thought it already answered in Bruen 2022. Does the Second Amendment require historical justification for modern carry restrictions? Bruen held that governments must show historical analogs from the founding era to justify restrictions on bearing arms. Hawaii argues it isn't restricting carry at all. It's regulating property rights. Plaintiffs counter that Hawaii's law suppresses carry by changing the default presumption of legality, something no founding era law ever did. Lower courts have been divided since Bruen. The Second, Third, and Ninth Circuits have issued conflicting opinions on what text, history, and tradition actually means. Wolford gives the Supreme Court the opportunity to clarify whether Bruen was meant to be a strict test or a flexible balancing test, dressed in historical language. How they answer will determine the future of every major Second Amendment case currently in litigation, from magazine bans in Duncan versus Bonta to assault weapons in Miller versus Bonta to sensitive place laws. Hawaii's law reverses the basic assumptions that govern constitutional rights. Historically, rights are presumed exercised unless an individual or entity objects, not the other way around. Trespass laws have covered this for centuries without requiring government intervention. The state now argues that because a property owner could exclude firearms, the state may exclude them on the owner's behalf. That argument essentially converts a private choice into a state mandate, and the court has rarely accepted such substitutions. The closest analogs are property-based speech cases, such as Pruneyard Shopping Center versus Robbins, where the court refused to let the state override property rights to expand speech rights. Wolford asks the inverse. Can the state override property rights to restrict gun rights? The court's answer will define the boundary between personal autonomy and state power. If the government can invert constitutional defaults using property regulation, nothing prevents similar moves against speech, religion, assembly, or even digital rights on private platforms. Wolford also raises a broader issue. What happens when states openly defy Supreme Court rulings? After Bruen, states like New York, New Jersey, Hawaii, and California enacted new laws that technically complied with the text of Bruen, but practically achieved the same old restrictions. Sensitive place expansions, training mandates, processing delays, and default property bans were all designed to shrink carry without explicitly banning it. The Supreme Court rarely tolerates long-term resistance to its rulings. We've seen similar conflicts in Cooper versus Aaron 1958, state defiance of Brown, Dickerson versus the United States 2000, rejection of congressional attempts to override Miranda, and McDonald versus Chicago 2010, and corporation disputes after Heller. Wolford gives the court the chance to decide whether Bruen was advisory or binding. That question matters far beyond guns. It's rare to see such clear geographic and ideological divides. The states supporting Hawaii are largely concentrated in the coastal and northeastern corridor, jurisdictions with dense population centers, strict permitting systems, and aggressive post-Bruen legislative packages. The opposing coalition is dominated by interior and southern states operating under constitutional carry, shall-issue systems, or permitless frameworks. The court respects federalism, but it also avoids fragmented constitutional landscapes. It rejected such fragmentation in Riley versus California 2014 on cell phone searches, and Carpenter versus United States 2018 on digital privacy. Wolford presents a similar problem. Does the right to bear arms mean different things depending on which airport you arrive in? A nationwide right that depends on geography is not a right. It's a privilege. Wolford is not technically a permit case, but the ruling will define how far states can go in attaching conditions to exercising the right to carry. For decades, restrictive states have used administrative burdens as functional prohibitions, processing delays, subjective standards, interview requirements, psychological checks, and mandatory training with narrow scheduling. Those tactics were designed to make carry rights technically available but practically inaccessible. Post-Bruen, those systems have come under fire in cases like Antoniuk versus Hochul in New York, attacking sensitive place laws plus administrative slow walking, Coons versus Platkin in New Jersey, challenging insurance fees plus burden stacking, Bonta versus Miller in California, focusing on training and discretionary review, and Ocean State Tactical in Rhode Island, pushing the boundaries of historical justification. Wolford adds a new dimension. Can states extend control through property rules rather than permitting rules? If the court treats property presumptions as a backdoor permit requirement, it could sweep away regimes that make carry contingent on government permission. Even shall-issue systems may be tested if delays or discretionary components are reinterpreted as infringements rather than administrative necessity. The broader question is structural. Does the government get to define the default condition of a constitutional right, or does the Constitution define the default and require the government to justify departures? The court has answered that question for speech and religion. It has never answered it for carry until now. For 15 years, the court has gestured at the idea that the Second Amendment should be treated like every other individual right. Heller, 2008, confirmed its individual nature. McDonald, 2010, incorporated it against the states. Bruen, 2022, guaranteed public carry under a historical framework. But the lower courts have continued applying doctrines that no other right faces. There are no sensitive place equivalents for speech, no good cause test for religion, no default ban rules for publishing, no insurance mandates for assembly. These tools exist only in the Second Amendment context. That discrepancy is the definition of second-class treatment. The Supreme Court has already signaled discomfort with this doctrine in Caetano versus Massachusetts 2016, and again in Bruen, where the court warned that lower courts may not reduce the Second Amendment to a balancing test. Wolford is the enforcement phase of that warning. If the court rules that property presumptions, sensitive place expansions, and post-Bruen resistance mechanisms violate the text, history, tradition framework, it will finalize the transformation of the Second Amendment from a conditional public safety privilege into a fully recognized constitutional right. If it declines, it effectively authorizes a two-track right system, ordinary for speech and religion, discretionary for carry. That outcome affects everything that comes next, from magazine bans to AR-15 cases, to ammunition restrictions, to public carry during emergencies. Oral arguments are set for January, but the real preparations are already underway. Plaintiffs are coordinating with states in the support coalition to present a unified historical argument under Bruen. Hawaii, backed by blue coalition states, will frame the case as a property rights dispute rather than a Second Amendment dispute. That rhetorical shift is intentional and, if successful, could give restrictive states a long-term workaround for Bruen. Meanwhile, gun rights organizations are timing other filings around Wolford, hoping the court will clarify multiple unresolved questions in one ruling. Expect a surge of challenges either immediately before or after the decision, similar to what followed Heller and McDonald. The court also has to decide how broadly to rule. A narrow ruling could strike Hawaii's default rule while leaving permit systems intact. A broader ruling could collapse default restrictions and force states to rewrite carry statutes. The broadest ruling, unlikely but possible, could treat permit requirements themselves as unconstitutional, accelerating the national transition to permitless carry. Regardless, Wolford will reshape Bruen's implementation phase, the same way Brown reshaped Plessy and McDonald reshaped the post-Heller incorporation landscape. The real question is not whether Wolford changes the map. It's how fast and how far the change travels. The permit era is being tested. Wolford versus Lopez is not just about Hawaii. It is about whether states may convert constitutional rights into conditional privileges. If carry rights depend on obtaining permission, they cease to be rights at all. For gun owners in restrictive states, the stakes could not be higher. A broad ruling could break the cycle of defiance after Bruen and compel the lower courts to apply the Second Amendment with the same seriousness as any other right. Whatever side of the debate viewers are on, this case marks a defining moment in the legal status of the Second Amendment. The Supreme Court has stepped in. The briefing coalitions are set, and the national fight over permits is now before the justices. If you want to stay updated as oral arguments unfold and filings continue, make sure to subscribe, share, and stay tuned. This is only the first phase of a much larger constitutional battle that will determine how Americans exercise self-defense outside the home for decades to come.